Good morning, everyone. Thank you for joining us for today's free webinar, 5 Ways to Reduce Employment Law Risks for Early Growth Companies, with Karen Reinhold from Hopkins Carley and Glenn McCrae from Early Growth Financial Services. My name is Erica Malsberg, and I'm the Chief Marketing Officer for Early Growth Financial Services, and I will be your moderator today. The presentation will run about 40 minutes or so. If you have questions as we go along, please feel free to enter them in the question field, or you can even tweet them to us at EarlyGrowthFS with the hashtag Employment Law Risk. We'll answer questions as they come if we can, or we'll wait until the Q&A at the end to address them. And if we run out of time, we'll be sure to follow up via Twitter and email after the presentation to make sure that all of your questions have been answered. So I want to start today by introducing our presenters. We are very pleased to have with us today Karen Reinhold. And Karen is the co-chair of Hopkins and Carley's Employment Law Department, where she specializes in representing employers, executives, and occasionally employees on employment-related matters. Karen served for 15 years as in-house employment and trial counsel for a large publicly traded corporation, and she also practiced law for many years with a large multinational law firm. In addition to providing advice and counsel on a broad range of employment-related legal issues, Karen has extensive experience as a trial lawyer, having successfully tried many employment or employment-related cases to jury verdict in state and federal court. So welcome to you, Karen.
Thank you. Thank you so much for having me. I'm pleased to be here.
Absolutely. And also on the line, although he may be joining us a little bit late, but we will have Glenn McCrae with us. And he's also from Early Growth Financial Services. He's our Chief Strategy Officer. In addition to being Chief Strategy Officer, he's an experienced CPA with extensive early stage company experience. Glenn's experience with smaller growth companies has helped him develop a deep understanding of how sales, strategy, financing, operations, and accounting each play a critical role in the successful growth of a young firm. So to start off today, Karen, it'd be great if you could just tell us a little bit about Hopkins and Carley.
Absolutely. As Erica mentioned, I have been practicing employment law for 30-plus years, and I've practiced both at a large multinational firm and in-house at a publicly traded corporation. For the last 5 years, I've been with Hopkins and Carley, and we are a mid-sized law firm. There aren't that many of them left anymore. They tend to be either really very large law firms or very small. We're unique in that we're a mid-sized firm with about 60 to 70 lawyers. We have offices in Palo Alto, California, and in San Jose, California, and we have a mix of practices within the lawyers here. We have a corporate department, litigation department, intellectual property department. We do patent litigation. I co-chair the employment law department. We both do advice and counseling on employment law issues and handle litigation related to employment law. We've got a real estate group, and we also have a very large wealth planning group, which often helps with people who have started companies or really hit it big and who need to engage in some wealth planning for generations to come. So in my own practice, I work both with very established companies, both private and publicly traded startups. I work with individual founders. Occasionally, I work with an individual executive or an individual employee who has a claim related to employment law. So I'm delighted to be here this morning to talk.
Thanks so much, Karen. It's wonderful to have you. And we have Glenn here, too. Glenn, could you start by telling just a few words about Early Growth Financial Services?
Sure, I'd love to. This is Glenn McCrae. I'm the Chief Strategy Officer at Early Growth Financial Services. We've got about 400 clients, primarily based in the San Francisco Bay Area, but we do have a national presence in New York, Chicago, Los Angeles, and other cities around the country. My presence here is going to be the advocate for the small company. The kind of situations that you'll come across from an employment perspective are the kinds of things that we help our clients with on a regular basis. Some of the things about whether you should be a contractor or an employee, how to deal with foreign folks, those kinds of issues are things that we deal with on a regular basis. So our basic service is providing financial services to the startup community, and we also provide 409 evaluations and taxes.
Great. Thanks so much, Glenn. So why don't we go ahead and kick off here?
So the question really comes up for early growth companies, given all the things you have on your plate, given that you're worrying about fundraising, financial systems, accounting systems, product market issues, et cetera, why worry about employment law risks at all? It often falls to the bottom of the list of things you need to worry about. And my point in talking about this today is not to overwhelm you with new requirements or issues that you need to worry about with an early stage company, but is instead to focus on 5 employment law risks that I think come up over and over again for both early growth companies and later growth companies. And they're issues that, one, you should have on your radar, and which I have some proposals for at least how to initially address the risks so that you're not taken surprised by it or not ignoring it completely, because these are all issues that if you take some basic steps, you can do something about. So the first issue I want to focus on is hiring employees. So if your company is successful, you're going to have to hire employees. You're going to have to hire key team members and build a team. And we know, at least in the Silicon Valley, and I think this is true in other labor markets, talent is scarce, particularly good talent. And so employers seek to handcuff and prevent competition for that talent. And they do that by using typically 5 different restrictive covenants. And all of these covenants that I've listed on this slide are meant to limit the flow of employees and customers from the employer or the company that's using it, the restrictive covenants, to someone else. So what does this mean for you if you're out in the marketplace hiring? Let's go through the covenants, and then I'll talk about the one that I think is the most important. There's 5 that I've listed here. One is a covenant not to compete. That's rarely enforceable in California, only when you're selling a company or you're a significant shareholder. Covenant not to solicit customers, no hire agreements, liquidated damages clauses, and covenants not to solicit employees. It's this last covenant that I want to focus on, which is the covenant not to solicit employees, because what does that mean for you if you're hiring, you're out there in the market hiring? So if you're hiring, you need to think about, and maybe some of you even have this in your own agreements, what kind of language is in the employment agreements that the people you are hiring had with their last employer or the employer before that. And this slide, which we call the standard non-solicit clause, is routinely used in the Silicon Valley and across the country, although there are variations from state to state. And if we go through the language, it's usually buried either in a proprietary information agreement or in a standard employment agreement. What it says is that the employee is going to be called upon to work closely with other employees, and that the employee expressly agrees that during their employment with the company and for 1 year thereafter, they will not solicit, take away, or assist any other individual or business in soliciting any employee of the company. It goes on to say that all the information about such employees which become known to the employee during the course of employment and which is not otherwise public is a trade secret and shouldn't be used by the employee. So what risk does this language create if you hire someone who signed it with their last employer? Well, we've got, Erica, if we could move to the next slide. We have here on this slide a basic example of how it comes up. Let's say you, new company, you hire a new VP of engineering. He comes from a more established company. And his task is to build an engineering team to help you get a product to market. So what does he do? He sets about trying to build a team, and the first thing he does is he starts hiring the best engineers from the last place he worked. And he's successful in doing that, and he hires 3 of the last company's engineers to follow him to you. Then what happens is the old company, potentially upset because they've lost a key group of engineers and they've got a product that's struggling now because they don't have those engineers to work on it, suffers a revenue hit, and they decide to sue not only that engineer who became your VP of engineering and hired their employees, but they sue you, the company that hired that VP of engineering, and claim that he breached his obligations to them in the non-solicitation clause, that you induced him to breach those obligations, that you engaged in unfair trade business practices, etc. Now, I know this sounds like a dramatic scenario, but I can tell you this fact pattern is directly out of a lawsuit that that we handled a couple of years ago, and it was against a startup who had hired away some key engineers from a more established company. And of the matters I'm now handling, I have at least 3 that relate to these kinds of issues, and they all kind of turn off of this non-solicitation clause language that employers are very often putting in employment agreements, and which is then being disregarded by employees when they move on. Most of the employees that are subject to this kind of employment clause, when you ask them later, do you realize you have a non-solicitation clause, they signed it so long ago and they paid so little attention that they don't even know they have it, so they're not being careful about whether they're violating or not. So I tell you this not to freak you out about hiring, but to suggest that there's some easy and fairly straightforward things you can do to try and reduce your risk. One is you need to set up a process by which, when you're making key hires, and potentially all hires, depending on how diligent you want to be about this, you go through a process of figuring out what agreements do they have with their prior employer. You ask them, you have an onboarding process that asks them, do you have a non-solicitation provision with your prior employer? If so, what does it say? You also ask them to sign an agreement with you, the new employer, that says, hey, we're telling you, don't breach any prior agreements you have with any prior employers. We don't want you to do that on behalf of us in either your hiring or performing your tasks for us. And that contract that you enter with them helps you defend against any claims that might be asserted against you, the hiring company, if they breach their non-solicitation provisions.
Wonderful, thanks. Oops, sorry.
Okay, let's move on to risk 2, compensation agreements. My experience with early growth companies is that they tend, unlike more established companies who usually have systems in place for where people get slotted on a salary structure or how people can be comped when they're hired, early growth companies tend to be creative with their compensation agreements, and that's because they've got more significant cash flow issues. Maybe they're wanting to incent people in certain ways to stick around. And there are a couple of common problems that are fairly easy to avoid, but that I see repeatedly. The first is structuring some kind of deferred compensation agreement that conditions payment of a, quote, salary on funding or other contingencies. I've seen repeatedly offer letters or employment agreements that agree to a base salary and then say, you don't get the base salary until we hit X level of funding. What's the problem with that? Well, under California law, the problem with it is that if it's a salary, it's owed to the employee, and it can't be made contingent absent some pretty extraordinary deferred compensation structures that are very expensive to put in place. It cannot be easily deferred or forfeited without exposing the employer to significant risk. So that in the example I described, if you entered an agreement that said, we're hiring you as our VP of marketing, we're going to pay you $120,000 of base, but none of that base compensation becomes due until we get our C round of funding of X amount, that salary is owed to the VP of marketing that you hired. They've worked, they've earned the salary, and under the labor code, you're not entitled to either defer it or forfeit it if you don't get that later contingency satisfied. So what happens then is the employee who has that agreement with you has the right to go down to the labor commissioner in California, file a labor commissioner claim, which is very easy to do in an office that's very pro-employee, and say, you know, X company owes me $120,000 in base salary for X amount of time. They failed to pay me. And I guarantee you very quickly the labor commissioner, when it goes to hearing, will reach a conclusion that you do, in fact, owe the money and that there are various statutory penalties that attach to that. Now, that's not to say you can't be creative with how you pay people, but you need to understand what the labor code requires and make sure you don't run afoul of that. So if you want to defer or not vest someone in compensation until something happens down the road, some other conditions are met, you need to structure it as a bonus plan. And you need to make sure your bonus plan has specific terms that says the employee's not vested in that bonus until X, Y, and Z occurs. They're not accruing it over time. They're not earning it over time. They vest in it when those various conditions occur. And if you do that, then you can go a long way towards structuring those kind of compensation of payments. And that's the second risk I have listed here, which is setting up a bonus plan that has terms that are ill-defined and that create actually vested rights in the employee to the bonus, which you don't intend to. It doesn't have to be complicated or extensive language, but it does need to make clear that the employee is not accruing that bonus over time or earning it over time, that they only become vested in it and entitled to it at the point that the conditions that you want to apply come into play.
So we have a question here from Carolyn. She wants to know, do you literally call it a bonus? Is that the language that you're supposed to be using?
Yes, I would. I don't know what other language you're thinking about, but it's very clear that bonuses under the labor code are contractual, meaning you're entitled as an employer to set up a contract that says when the employee gets the bonus. And that contract, absent it being really unconscionable, is going to be upheld by the court. So that means you call it a bonus because then you have created a kind of compensation that can be governed by a contract as opposed to the labor code. And then you very specifically in the bonus document define the terms that have to be satisfied before the employee is paid that bonus.
Great, thank you.
Okay, third risk here. Again, this is a risk. This risk comes up all the time for established companies, but I also think it's a very important risk to manage for an early growth company because it's very easy to ignore it. You're often very focused on just getting the work done and not thinking about how employees or independent contractors are treated. And there's often, in my experience, a real blurring of someone starting out as an independent contractor and then maybe moving into more of an employee role without anyone changing their status. So two important issues on this slide. Are you using independent contractors, and if so, are they really employees? There's a couple different legal tests for looking at this. The IRS has a test they like to use. The Department of Labor has a test they like to use. But what I like to distill it down to is a basic question, which is, are you, as the person who's using the independent contractor, controlling the manner and means of how they do their work? And if you're completely controlling the manner and means of how they do their work, then you're running a high risk that they're not really an independent contractor, and in fact, maybe they're your employee. And that's a serious issue because it raises tax issues, it raises penalty issues. It's something that the federal government has been looking at more aggressively because they see it as a revenue loss to them. So it's something that you need to pay attention to. I'm not saying don't use independent contractors. They definitely have a place. But when they're sitting next to your employees, they're doing work very similar to your employees. They're coming into your office, potentially using your tools and equipment, and you're controlling the manner and means in which they're getting the tasks done. I think you need to take a serious look at, are they really independent contractors, or are they really your employees? And should you go through some process of converting them to an employee, which I know can be tricky because there are many people who want to stay independent contractors for their own reasons.
And before we move on to the exempt versus non-exempt, Karen, one of the things I wanted to mention to people, this is a webinar around the employment law issues, but there are tax issues that we frequently deal with around independent contractors. First is you should know that before you pay an independent contractor the first check, you should make them fill out what's called a W-9 form. And that form, you can easily Google it and find it. It's a simple form to fill out. It just provides their Social Security number for you so that you can give them a 1099 at the end of the year, which is your obligation as the employer. And secondly, there's always the question of, gee whiz, if my contractor is not a U.S. citizen and they are not based in the U.S., do I have any special obligations with respect to that contractor? And the answer is no. There are no 1099 reporting obligations for foreign-based contractors working outside the U.S.
So Glenn, this is Karen. I have a follow-up to that. What's the ramifications for the entity using the independent contractor if they don't do the W-9 the way they should prior to the work getting done? How does that play out?
There are penalties that the IRS would levy against the company. They are both incident and time dependent. So the first late filing, let's assume that you've realized, and how's the IRS going to find out? Well, it could happen through them doing an audit of your company. It could happen through them doing an audit of the contractor and looking at their sources of income and seeing, oh, they've reported income, but I don't see an associated 1099 here. So there's a per incident fine. I believe it's about $75 per incident, and then there's a time fine depending on how long it's been since you filed the appropriate 1099. And the penalties can get pretty significant over time.
Right. And we're seeing an increase, and I don't know if you are with early growth, of audits being conducted on this. I know that the Department of Labor and the IRS have teamed up, and they seem to be putting a little bit of extra energy into it, as does the Employment Development Department, which is another, a state agency that can get you into trouble with this.
And you're probably right about that, because of the use of contractors is increasing these days. There's a lot more independent contractors than there have been in the past.
Right.
And we have a couple of questions about that before we move on. Someone just wants to confirm a 1099 is an annual filing. Is that correct?
Correct. It's called a 1090. There are all different types of 1099. Some deal with interest payments. Some deal with mortgage payments. This one in particular is called the 1099 MISC for miscellaneous. And it is due annually. The employer is supposed to file it with the contractor by January 30th of each year, and then you have to file a different copy with the IRS by February 28th.
Okay, great. Thank you.
Was there another question on independent contractors, or shall I move on to the exempt versus non-exempt?
I'm going to clarify with the asker, so you can move on, and then I'll pop back in.
Okay.
Thank you.
So the other issue we have that's related to this issue of independent contractors is if you're hiring people and you're making them your employees, in California there are rules that govern this, and also under the federal system there are rules that govern this, and that is the question of, are they an exempt employee versus non-exempt employee, and what does that mean for you as the hiring entity? If they're an exempt employee, and I'll talk in a minute about how we know whether they're exempt, it means that you don't pay them overtime when they work more than 8 hours in a day or more than 40 in a week. It means you don't need to worry about whether they're taking a unpaid relief from duty meal period every day as California requires. It means you don't need to worry about whether they're taking rest breaks. And that's all very important. So how do we know whether someone's exempt versus non-exempt? There's a lot of confusion around this. Most people say to me, well, I paid them a salary, so they must be exempt because they're not an hourly employee. Well, the fact that you paid them a salary is only one piece of the question. In order to be exempt under California law and federal law, you both need to be paid a certain way, which is you need to be paid on a salary basis, and two, you need to be in a certain category of work or a certain classification that is characterized as exempt under both California law and federal law. There's a professional exemption, an executive exemption, and an administrative exemption, and they're not as easy to hit as people think. So it's important to look at that, what we call a duties test, to see if your jobs or your employees fall within one of those exemptions. There's also one that's very important, and it's listed here on the slide in California in particular, and that's a computer programmer exemption. There's a specific exemption for computer programmers, but you need to remember that it's just not anyone who works with a computer. They actually need to be doing a certain type of work, and there are minimum pay requirements right now, and it keeps getting raised every year to correspond to other increases. you've got to pay them a certain amount per hour, and it comes out to, I think right now, $84,000 a year in annual salary if you annualize it. So you should have, even if you're a very small company, some system in place that when you're hiring an employee, you are asking yourself, is this person exempt or are they non-exempt? Where do they fit within that paradigm? And if they're exempt, then you can, quit worrying about, are they getting meal periods, are they taking breaks, etc. But if they're non-exempt, and I would encourage you to not just think the only people who are non-exempt are admins who support someone, but that there are some other people who also qualify as non-exempt. You need to then, and we'll pick this up later when I talk about policies, you need to make sure that you've got a system in place for paying them, if you're in California, overtime for every hour they work over 8 hours a day. You need to have a system in place that makes sure they get paid for every hour they work over 40 in a work week. You need to make sure they're taking a meal period, an unpaid meal period during which they are relieved of all duties for 30 minutes, no later than the end of the 5th hour or the commencement of the 5th hour of their work for you. And they're also entitled to 2 rest breaks during the day. So what are the consequences of failing to do that? If you've done any reading at all, you'll know that there's a huge cottage industry around wage and hour class actions. There are a lot of lawyers out there who love to form a class action around non-exempt employees who aren't paid properly. And then there's all kinds of statutory penalties that attach to each incident in which the employer doesn't give them a meal period or a rest break. And then there are attorney's fees under the code. So it's a highly desirable area to be plaintiff's counsel on and to create a class action because big money can be recovered. So although this is an incredibly mundane and I would say tedious task, it's really important at the front end of ramping up your employee base that you set up some system to address exempt versus non-exempt, tracking that, making sure you've got it right, and going back and looking at it occasionally. Because in the beginning it doesn't seem like a big deal, but when you suddenly have 30 or 40 employees and maybe 10 have been misclassified for 2 years, if we were to start to run the numbers of your risk, it would be pretty significant financial risk, and it is not that easy to correct once you're halfway through it because it raises a real red flag when you start changing employees' classifications after they've been classified one way and worked for you for 2 years that way. So I would really encourage you to pay attention to this exempt versus non-exempt issue. I think it doesn't get as much attention with smaller early-stage companies as it should because it's just not that high on the list of many, many things that need to get done, but it is something that if you even spend a little bit of time at the front end, you can really mitigate the risk of this coming back to bite you later on.
Great, thanks. And going back to the tax issue, Alexandra was curious whether there are any taxes associated with using a foreign contractor through a platform like Elance.
I will tell you that if your foreign contractor is not a U.S. citizen and they do not reside in the U.S., then the answer is no. I don't really think it matters how you access that contractor. I think the real question is, do you know where they reside and do you know what their nationality is? If they're a U.S. citizen, you're going to need to get a W-9 from them.
Okay, thank you.
Okay, the fourth risk that I've listed here as the top 5 risks are confidential information, and are you protecting it? It is always surprising to me how careless companies are with information that is extremely proprietary to them and extremely important to their business. And I don't know if it's because it often, early stage company involves people who know each other well and they're working together and the assumption is we're all in this together and we're protecting it, but I have seen many, many times a lack of systems or process in place to protect confidential information. So it's true there's trade secret laws in California and federally that protect you against misappropriation of trade secrets, but they're all predicated on the fact that you as an employer or a company have actually taken appropriate steps to keep that information confidential. If you aren't doing that, then you can't meet the test for whether the information is actually a trade secret. So there's some basic steps that everyone should be taking if you have confidential information that's important to your business plan, and most companies certainly do. And that is, do you have documents and a process in place for onboarding of either employees or contractors that force them through a channel where they sign a proprietary information agreement or an employment agreement or something, an NDA, something in which they commit to you that they understand if they have access to confidential information, they are not going to use it in any way other than as is appropriate on behalf of the company. Second, I think it's extremely important that you designate a point person for tracking and collection of those agreements. It's often a kind of a scattered affair, and the more scattered it is, the more likely it is that someone's not going to sign the agreement and you're not going to be aware of that. So simple enough to designate one person, someone who's responsible and central in other ways to administration, to be the point person for tracking and collection of all of those agreements and managing the onboarding process. Third, I think it's useful if you can have another process or policy in place regarding use of handling of confidential information during employment. It doesn't have to be complicated, but it should reiterate the things that should be in the proprietary information agreement, that information shouldn't be used for inappropriate means, that you shouldn't be distributing it to third parties without permission, etc. Some pretty obvious things. And then fourth, most importantly, and this is where many companies fall down, you need to have an exit process in place whereby employees and or contractors who are departing reaffirm their obligation to you to keep certain information confidential, and also an exit process during which you take back what they have that belongs to you. In this day and age of electronic data, there is so much data in so many places that it is just inordinately common for employees to leave and to still have your data in their possession. We're right now in the process of representing two very senior technical people who left one company and went to a new company, and immediately they got the letter from the company that they left saying, you know, we're watching you because we're concerned about you using our data. And inevitably, when we go through the audit process to make sure they really don't have anything in their possession that they shouldn't, we look at all of their media, we look at their email, we look at all of their cloud-based stuff. We inevitably find data that belongs to the prior employer that they've inadvertently kept, don't intend to have, and don't necessarily intend to use for any bad purposes. So it's really important you have some kind of exit process where you ask the question, have you returned everything that you have of ours? Does that include X, Y, and Z and all of the things you can think of? And then that you have the employee or the contractor sign off saying, yes, I've done that, and you've gotten it all back.
So we have a question here from Tom. He wants to know how clearly you need to outline what qualifies as confidential information.
That's a great question, Tom. I think it's important to do it as specifically and as clearly as possible. Employers have a tendency to say something like, everything you learn here is proprietary and confidential and belongs to the company, and you may not use it for any other purpose. And that's kind of an overly aggressive position, which I think subjects the company that says that to risk. So whatever your business is, you need to think about, what is it about this that we really consider highly confidential? And to the extent you can come up with some specific descriptions of those, that's extremely helpful. Now, you might also want to say including but not limited to, so it's not exclusive. But to the extent you can come up with specific language, I think it's very helpful. It helps you later, if you end up in litigation around it, and it also just helps educate your employees. Because I, for one, believe that if you simply tell people, as the last big piece of litigation we had, the employer had done, everything you learn once you start at work from the moment you enter the building to the moment you leave is ours, belongs to us, and you may not misuse it. I mean, that's a ridiculous position. It's hard to defend. And it also just doesn't give the employee any guidance about what are you really talking about. Are you really saying the joke so-and-so told me today is confidential? Of course not. There's some specific technical and personnel and business information that is confidential, and we shouldn't be shy about saying what that is, because it just helps you in the end if you get into a fight about this.
Great, thanks. That's super helpful.
Okay. I am not here to advocate that you have an exhaustive, lengthy employee handbook. I worked at a big publicly traded company. We had a handbook and policies that you just wouldn't believe. It was a nightmare. Even I couldn't keep track of them, and it was part of my job. I'm not advocating that kind of a system because I don't think it serves you well as an employer, and I don't think it serves employees well. But I do think there are some basic written policies that any company with even a few employees should have, because they're simple policies, they mitigate your risk, and they help your employees. And I've listed those 4 here. The first is some kind of policy that, some written policy that forbids harassment on the basis of sex, race, other protected characteristics in the workplace, and which within it sets up some kind of reporting or complaint system so that if someone who works for you thinks they're harassed, they have an open door to go complain about it. Why do I advocate for this? Because harassment cases have a defense to them, and that is that you took immediate remedial action and you addressed whatever the problem was. And to take advantage of that defense as an employer, you need to know that someone thinks they've been harassed. So, and one of the first things in the cases that any court or jury looks at in determining whether you created a workplace free of harassment is, did you have a policy that forbid it, and did you have a system for reporting about it and getting it corrected if an employee thought they were subjected to it? So it's a very simple policy to have. You should have it in writing. It should be posted and or distributed to your employees, and preferably they should sign off that they received it, or you should have some system by which you can prove that employees received it. The second policy is some kind of equal employment opportunity and non-discrimination policy. All employers are subject to the obligation to hire without regard to race, sex, national origin, age, etc. If you fail to have this policy, which we see all the time in ads and otherwise when people are hiring, in writing, it's just a mark against you if you end up with a claim against you. So there's absolutely no downside to having this policy. It's very simple. Put it in writing, post it, or distribute it. The last 2 policies that I recommend are more specific. The third is this meal period and rest break policy. This applies if you have any non-exempt employees. If you have any non-exempt employees, you need to have, and particularly if you're in California, I can't emphasize this enough, you need to have a policy that says you are guaranteed a 30-minute meal period during which you will be relieved of all your duties no later than the 5th hour of your work. If you don't get it, tell us and we will fix it. And you're also guaranteed rest breaks, and those break down by certain hours. It can be a 1-page policy. Why do you need this? Because what will happen if you don't have it is someone will work for you for, let's say, 6 months to a year. They'll become disgruntled. Maybe you'll become disgruntled. You'll fire them. They're non-exempt. They'll go down to the Labor Commissioner's office and they'll say, wow, I worked at this wild startup. It was always so busy. I could never take lunch. I could never take my breaks. I never got them. And they'll fill out a form, and you will be subject to penalties, assuming that it is found against you, for 1 hour of their time for every day they miss their meal period, and 1 hour for every day they miss their rest break. And the presumptions that are built into the Labor Code and the Labor Commissioner's office say that if there are no records about it, and if there's no evidence around it, which there typically is not, other than what the employee is saying, the presumption is against you, the employer. So if you put this meal period and rest break policy in place, what it allows you to say is, we distributed this written meal period and rest break policy, and we told non-exempt employees, if you don't get your meal period, if you don't get your rest break, come and talk to so-and-so, and we'll make sure you do. And then you've created a defense and evidence you can use when an employee goes down to the labor commissioner's office and says, I didn't get my meal periods. So it's simple, easy to put in place. It will help you enormously if you get this kind of a claim against you. And I know it's not a sexy issue, and it often seems when a company is first starting and everyone's working hard and everyone's excited and you're bringing in lunches and you're staying late, that everyone's on the same team and no one's going to complain about this. But, you know, things change just like in any relationship, and when people become disgruntled, they can make these kinds of claims. So it's important to put something in place to address it early on. Finally, the last policy that I recommend you have is, and this is one that requires a little bit of thought on the employer's part about how they want to establish this. What kind of computer policy are you going to have? Are you going to let employees bring their own devices to work and use them and put your data on those devices? If you're going to require them to use only your computers, then that needs to be articulated. You also need, if you're letting them use their own devices, or even you're providing all the computers, something that preserves your right to access those computers at all time and check on what's going on, so the employee has no expectation of privacy in that computer and what they're doing on that computer. That requires some thought about how you're going to handle devices and whether you're providing them or you're allowing employees to use them. Social media policy on this, you need to think about who do you want to be able to speak on behalf of the company. You can't prevent employees from using social media and making statements about you. You can't completely prevent that because the law and just the practical reality won't allow you to, but you can have some policies in place that say only certain people are allowed or authorized to make statements in social media on behalf of the company. And I think that's something in this day and age that it's important to get in place, particularly if you're planning on using social media in how you promote the company, et cetera. So I think all four of these policies are fairly simple to develop, fairly simple to implement, and they all have huge effects on mitigating risk that comes up easily in early stage companies. And so I'd recommend that all four of these be put into writing by companies early on.
Someone wants to know here, they said years ago they heard an arbitration policy is absolutely necessary. What are your thoughts on that?
That's an interesting question. The question is, what about an arbitration policy? So that was actually a very hot topic and has been over the last 10 or 15 years. And the thought was, let's have every employee or contractor sign an agreement that says if there's a dispute, we go to binding arbitration instead of that employee being allowed to go to court and get a hearing in front of a judge or a jury. So the problem with that in California is there's been an ongoing battle, which is not yet resolved, about when those arbitration clauses are enforceable. So if you have one, which I'm not against having them, you should expect that if an employee wants to avoid arbitration, they will simply file in court, and then you have to go and try and compel arbitration, and then there's going to be an argument about, is the arbitration clause unconscionable? Was it a contract that was presented to them that they couldn't negotiate around? Is it fair to the employee, et cetera? And so there's been a lot of challenges. I have some clients who still want to use them, and we try to use them, and they've had some advantages. And I have other clients who say it's not worth the legal fight these days because the law is unclear on whether they're enforceable in California. So I would not agree with the statement that it's an absolute must-have, because the truth is there's no guarantee that it's enforceable. It can have some benefits, but it needs to be done well, and the process that you put in place for the arbitration needs to have enough due process and fairness in it that the employee can't argue around it. So it's not a simple, easy fix to potential legal claims, and I'm not recommending it to all clients these days.
Okay, thanks. And another question here from Robert. He says, we don't have a physical office. All our employees are remote. How do we disseminate these policies? Via email, okay?
Yes, absolutely fine to do it through email and acknowledgement, et cetera. And that raises the other question of how do you monitor the meal periods if they're not on site. Maybe they're all exempt and that's not an issue. But nonetheless, if you distribute it electronically and you get acknowledgement, it's not a problem. You can do it that way.
Okay, thank you.
So the last slide here, and to wrap up today, is I don't want to burden early stage companies with focusing only on managing employment law risk, which I think is sometimes how employment lawyers come across. It's one risk in one area you need to worry about, along with many, many other things you're juggling. And so what we tried to do today is to identify some simple steps you can take to substantially mitigate your risk. And the first one is an onboarding process that identifies and manages this risk of does the employer you're hiring have some kind of non-solicitation or non-compete covenant that you should be worrying about as an employer. Two, to look at your compensation agreements and make sure you're not, by deferring comp or how you structure your bonus, somehow either inadvertently violating the labor code or vesting employees in bonuses that you don't want to vest them in yet, and which you are actually not intending to pay them until certain conditions are met. Three, scrub your independent contractor relationships to make sure these people are truly independent contractors, not only on the way in the door when you set it up, but once a year or so. I think you should go back and look at them and say, okay, how many independent contractors do we have? Are these people really independent contractors? And I know this is a touchy issue. I have worked with many clients where it's not the employer that's resisting turning it into an employment relationship, it's the contractor. And all I would say is I think it's worth spending some time to get that right, because Glenn mentioned some risk and there are other legal risks that go along with this. Next issue, set up some simple employee classification system where you at least have a sheet of paper on which you're checking a box and thinking about, is this person exempt? Are they not exempt? Why am I saying that? And track that. And then put a little bit of energy into figuring that out so that you don't end up having a bunch of people who you're paying on a salary basis, not paying overtime to, not giving meal breaks to, who really are not exempt from those requirements under either California or federal law. On the confidential information issue, just make sure you have some processes in place that protect what it is you think is really important, both that you tell employees on the way in the door, this is what we treat as confidential, here's what we expect of you, and that you process when an employee or a contractor leaves you to make sure you get information back and you have them reaffirm their commitments to you. And then finally, the basic 4 written policies that I mentioned. Get those in place as soon as you can. Post them, distribute them by email, have employees acknowledge that they received them in some way. It's simple enough to add a line that says, I acknowledged I received these policies on such and such a date. Stick that in their personnel file. It seems like a simple thing, but often when you end up in litigation, I have employers come to me and say, okay, we have these policies, and I say, okay, well, show me where it shows that you gave it to the employee, and there's this failure of proof there because we don't have that missing link. So that's a simple thing to correct and takes very little time. Okay, that's all I had for today.
Great. Thank you so much, Karen. We have a little time here, so if anyone has any questions, you're welcome to enter them now into the question field, and we can take them as they come in. If something occurs to you after, feel free to follow up with Karen or Glenn individually or together. You can see their contact information listed right here. Okay, it looks like we don't have any other questions right now, so we'll end a little early today. Thank you so much to Karen and to Glenn. I think this was a really informative webinar, and I hope that you all found this information to be really useful. And thanks so much to all of you for attending. We really appreciate your time. Just to let you know, our next webinar is scheduled for June 19th. It's called 10 Simple Ways to Raise Venture Capital. For this presentation, Gadiel Morantes, who's our Chief Revenue Officer, will be in conversation with Ryan Aslan, who's a partner with Stubbs, Alderton, and Markiles, discussing simple steps you can take to get you closer to landing your next round of investment capital. And then we have another one on the 30th with one of Karen's colleagues, with Alain Levy. It's picking up on a little bit of what she was talking about with protecting confidential information. He'll be talking about the 5 IP mistakes that early stage startups often make and how to protect yourself. So feel free to check out our events page on our website to sign up for any of these webinars or check out some of our upcoming events. And we hope to connect with you all again real soon. And thanks again, Karen. This was wonderful. Thank you for your time.
Absolutely. Delighted to be here.
And thank you to you too, Glenn. Thank you. So have a wonderful day, everyone, and a great week. Bye-bye.